Well, the Supreme Court has granted review of a case challenging the scope of the Clean Water Act. The long-running dispute started back in 2004 when an Idaho couple and the EPA over an area of their property the agency deemed a wetland. Well, Roger McEowen with the Washburn University School of Law joins us now with the latest in today's Rural Money segment. And Roger, certainly is a hot button issue. Let's start first of all with just a bit of background on the case and how we got here.
Well, you're right, Janet. They did buy this property in 2004. It's a lot, a little bit more than a half acre, and it's about 100 yards away from a lake that is a navigable water of the United States. But there's no surface water on their lot that flows into this lake. But the EPA asserted jurisdiction over it on a nexus type theory. And they sent a compliance order out, not a final determination, but a compliance order, and said, basically, you better stop or you're going to have to pay fines of $40,000 per day. Well, the Sackett sued, and it got to the U.S. Supreme Court, and the Supreme Court said, no, these compliance orders are unconstitutional. You can't do that. So it kicks it back to the Ninth Circuit eventually. And the Ninth Circuit, on the merits, said their lot is a jurisdictional wetland subject to regulation under the Clean Water Act. And now that's the issue that has filtered back all the way to the U.S. Supreme Court. And yesterday, the court said, all right, we're going to deal with the core issue here and determine what rule we use to determine whether and what is a jurisdictional wetland under the Clean Water Act. This is the first time they have dealt with this issue since 2006.
So, Roger, where do we go from here now?
Well, we got two things going on. We have the Biden administration that has put out a proposed rule, and now the Supreme Court saying, we're going to tell you what the rule is. So this has the potential to wipe out whatever the Biden administration is coming up with. And their proposed rule would really be expansive and take us back to the 1986 test, which has been heavily litigated. And I think the court is seeing this and saying, all right, we're going to grab this one by the horns. And probably, if I'm reading the tea leaves right, they're going to use the plurality opinion in the Rapinos opinion in 2006, which, bottom line, that'd be pretty good for agriculture if they do that.
Roger, what would be your big takeaway from this? And also, do you have any guess as to a timeline when we might have an answer?
I'll take the second question first. Timeline, I think they will render a decision by the end of June this term. So since they granted it this fast, I think that means we're going to see the opinion by the end of June. It may not be one of the last ones that come down, but it could be. But I think it'll be this term. This is really going to help us define, I hope, finally, what the government's definition of a wetland is. And so that's what we're going to have to watch for. Big issue for agriculture. This affects a lot of people all across the country.
Roger, I want to sneak in one more question on another topic, but still related to SCOTUS. We're waiting for them to make a decision regarding Prop 12 in California. They keep pushing that decision back. Any thoughts there?
You know, I find that interesting. I think that's a great question. They were going to give us their opinion at their conference a week ago, almost 2 weeks ago now, and then they passed on it. Then they passed on it yesterday. The next conference is in February. I think it's a Friday in February, whether it's the 8th or the 18th. I can't remember off the top of my head. I don't know. I don't know what that means by them keeping it alive. There must be something that is under deep consideration, but that's also important for agriculture to keep an eye on.
All right, Roger, as always, thank you very much for your insight this morning. Roger McEowen, he's with the Washburn University School of Law, connecting with us today, of course, out of Topeka, Kansas. Thank you, Roger.